Okay, let's get started. So my name is Anton, and want to welcome you to this webinar. So it's a good morning or a good evening or a good afternoon to wherever you are in the world. So this presentation is aimed to help inventors or people with inventions to secure patent protection. So typically these sorts of people would go and see a patent attorney to help them write a patent application. And writing a good patent application is a bit of an art. And so hopefully this webinar is going to demystify some of the art form that exists, and also to help inventors to save time and money to make sure that a good patent specification is written. So before we start, I just want to run through a bit of housekeeping. I will be taking questions or answering questions at the end. And for that, you can go into the Q&A portal to ask your questions. Hopefully we'll be able to get through a good number of questions at the end, but if not, then you can email your questions to marketing@ajpark.com, and we'll get back to you with a response in the next few days. So this presentation is a general overview, and often, well, all the time, fact situations are different. So if you have any specific IP needs or advice, then it's important to get specific advice. So this is a general presentation, hopefully of use, but if there are any specific questions that you might have or needs, then it's important that you go and see a patent attorney to address those. So this webinar is being recorded, and in the next few days, the webinar will be made available online. So our marketing team will communicate that to you. Okay, a little bit about myself. I am a mechanical engineer originally, and also a lawyer. I joined AJ Park about 27 years ago and qualified as a New Zealand and Australian patent attorney. So I work with a large number of clients, both small to medium enterprise, a lot of startup work, and I also do some work for larger corporates here. I also lecture in patent drafting, and I am a principal here at AJ Park. But what I call myself is a patent attorney. So I could also call myself an IP lawyer, but I feel that probably the most important part of my education is my mechanical engineering degree, because I use that every day when I talk to inventors about their inventions. It helps me to talk shop with the inventors very quickly and to understand what it is that they've invented. Okay, a little bit about AJ Park. Probably a significant note is that we're 130 years old this year, which we're very proud of. So we employ over 200 people, and it's a lot. New Zealand is a very innovative country, and a lot of IP rights are being pursued by New Zealand businesses, and particularly filing those IP rights overseas. And also a lot of our work involves helping foreign IP owners to secure their IP rights here in New Zealand. Okay, so let's get started. So what is an IP, or what is a patent attorney? So there are many different names or titles that people in the IP service industry give themselves. I consider myself a patent attorney, but I could also call myself an IP lawyer. There are also IP consultants out there. There are people that are trademark attorneys, and some people call themselves IP attorneys. So there are globally a lot of different names that are used by IP service providers. It's a real mixed bag as to what people actually do with these titles. So traditionally, a patent attorney will deal with patent filing work, whereas an IP lawyer may do IP litigation work. But many of them do both, including IP strategy. Here in New Zealand, a patent attorney is a specially qualified person having sat patent attorney exams. And under our new regulatory system, anyone newly qualifying must pass a master's in IP course at a university, and also have a technical qualification. Okay. So there are many people qualified as lawyers, but not necessarily as patent attorneys. In the end, if you're looking to engage an IP professional, don't go purely by the title of the person that you're going to engage. You really need to dig a little bit deeper to understand the nature of the work that they do and the experience that they've got. This is really important. Okay. And I'll touch on that again in a minute. There are also some patent attorneys or IP lawyers that you can't hire. So they're not in the service industry. They're actually people that work in-house. And there are a reasonably large number of our clients that will have in-house patent attorneys working for them. Companies like Xero, like Fish and Paykel Healthcare, like Auckland Uni Services. They generate so much IP that they've actually decided to hire some people to do that work in-house for them. So what are some reasons for seeing a patent attorney? So a patent attorney can help protect your own IP. So that may be in the form of patents, trademarks, registered designs, and also with trade secret and confidentiality protection. Okay. A patent attorney can also help you to identify IP of others to make sure that if you're going to launch a new product, that you're not going to infringe someone else's patent or someone else's trademark. Patent attorneys can also help with commercializing your IP. So you may be interested in selling your IP or licensing your IP. Commercialization may also involve the use of NDAs in collaboration with others. A patent attorney may also be able to help you with IP strategy and with IP enforcement. But as mentioned before, not all, and in fact most IP service providers don't do all of these things. But an IP firm such as AJ Park can help cover all of this territory by having an IP team that can cover this territory, this ground. Okay, so this webinar is focused primarily on patents. So patents protect innovations and they can stop someone from copying your product. But they can do more than that. They may even be able to stop others from copying your invention. So an invention is often something a lot broader than the product that's been invented. An invention is usually about the concept that resides in the product. So let's say you've invented the wheel and you make a unicycle out of it. Okay, so the unicycle is your product, but you may be entitled to a patent for the wheel. Okay, not necessarily the vehicle, the unicycle that you've developed. And the patent for the wheel may be so broad as to cover mechanical gears or even balls or grinding the discs, anything that is round. So patent is usually about the technology. And this flowchart here is to help you understand what kind of IP right you might be talking about. It might be a little bit hard to see the detail, but this flowchart is also available on our website. And you plug in a new idea at the top, and then the flowchart takes you through some questions. And out the bottom, you'll land in maybe one or two or maybe three of these bigger circles. That'll help you identify whether your new idea may be a brand and therefore trademark rights are important, or it may be about a product or process, in which case registered designs, patents, trade secrets, and copyright may be important. For a number of inventions, a number of IP rights may be applicable. So patents provide protection for inventions to stop others from copying. Okay, and so inventions may reside in the form of products or a process or a formulation, and also in software. And patents can prevent others from copying that invention. Patents last for 20 years and can be a really, really strong right to have to give you a commercial advantage in the market. And for some companies, patents or IP rights are the only form of asset that they have. For a lot of my startup clients, IP rights are the only asset because they're renting everything else, or they may be working from their parents' garage still. They reckon that in the 1970s, around about 7% of assets of S&P 500 companies resided in intangible assets. And now they believe that's around about 90%. You might go, well, that's a lot. But when you think about it, companies like Uber and Airbnb, they don't actually own any tangible assets. Well, they might do. They may own some offices and some office furniture and computers, but they certainly don't own any cars or hotels. So how do you even get a patent? So a patent, what we need to do is if you're wanting to secure a patent for your invention, you need to file a patent specification at the Patent Office. Okay. Then that gets examined by the Patent Office to make sure that you're trying to protect something which is unique compared to what's already out there. And once it's approved, you are then given a granted patent. So before it is approved, you have patent pending status, but after that, once it's approved, you have a granted patent. And the aim of securing a patent is to get as broad as possible protection or coverage that you're entitled to. Okay, so patents, as I mentioned before, are for inventions, and inventions are about the concept that resides in products. Okay, and I'll explain this to you with some cool diagrams in a minute. So the scope of a patent or the scope of patent protection that you might be eligible for is really primarily dependent on how unique your invention is compared to the current state of the art. Sometimes call that prior art, and I might use that term interchangeably. And also how good your patent attorney is. Okay, so let's have a look at what I mean by that last section. So the invention and the scope of a patent. So often inventors will come and see me and they'll come into a meeting room and they'll put a product on the table, or they may wheel it into the room. So let's say the inventor has developed the bicycle. Okay. What we will normally recommend before we file a patent is to understand what the concept in the product is and what unique concepts exist. Okay. And by understanding what is unique will help determine the scope of patent protection that we might be eligible for. Okay, so as the first step, usually when we prepare and file a patent specification, is to conduct some searching to see what the prior art looks like. So prior art is any prior use or prior publication of inventions or products that are similar. So you can see that the inventor has developed a product and the prior art sits around the perimeter here. Okay. And that means that potentially the scope of patent protection that you're eligible for is much broader and much larger than the actual product that's been developed. So the prior art is still outside of the scope of the patent. I mentioned before that we cannot patent anything that's old, and searching is going to help reveal what is old, and anything else that isn't old is eligible for patent protection. Okay. Here's an example of where potentially a poorly drafted patent specification has been filed. So the scope of the patent is far too narrow. You can see that the prior art is miles away from the scope of the patent that's been filed. Sometimes inventors say, well, I don't care about other applications or other uses of my invention, and I don't want to try and cover all the blank space that exists. I'm just interested in protecting my product and some slight variations around that. But what is worse is when a patent specification is written that completely misses protecting the product entirely. And I've seen it a number of times where the product sits over here and the scope of the patent resides there. Sometimes this happens because potentially originally the product sat within the scope of the patent, but through product development has migrated outside of it. Okay, so keeping an eye on where product development is going and the nature of the protection that you've got is also important as time moves on. Okay, so preparing a good specification. So you need to work with your patent attorney so that they get a good understanding of your invention and its commercially important novel features. Okay. So this should be done, in isolation of the business strategy. So a business strategy will help inform an IP strategy, and that will then help inform a patent strategy. Together with your patent attorney, you then need to identify the invention or inventions that you want your patent to cover, and then prepare a patent specification for filing. The preparation of a patent specification can take between a week for simple inventions to sometimes over a number of months for complicated inventions. So it can take quite a long time, depending on the complexity of the invention, to prepare and file a patent specification. So you need to take allow some time for that as well. So here are some steps that I think are important when you're going down the patent path. So pick an experienced patent attorney that's familiar with your area of technology. And I actually believe that this is really vital. I'm a mechanical engineer, and I certainly don't touch patents in the biotech sector. And even in electronic engineering, I don't write any patent specifications when it comes to electronics. So you'll be able to find online, if you're looking to engage a patent attorney, their credentials, their experience, their education, to be able to hone in on a patent attorney that's got the right technical background. Having the right technical background allows for that patent attorney to talk shop with you and to pick up your invention really quickly. And that's going to save time and money, and to make sure that the patent attorney, together with you, are looking at the variations of your invention that the patent specifications should cover. You should also ask about ballpark costs for the patent process. So once the patent attorney has seen a little bit of information about your invention, they should be able to give you a pretty accurate cost for the preparation and filing of the patent specification. Okay. The next step is the invention disclosure process. So this is where the invention and its detail is communicated by you to the patent attorney. So this is where you teach the patent attorney all about your invention. And I'll give you some examples of the things that should be covered during this step. I mentioned before that searching for prior publications can be really important, because that can help determine the likely scope of patent protection that you'll be eligible for. Sometimes this step is left out because there are time pressures to file a patent specification. A patent specification typically has to be filed before there is any publication or disclosure by the inventor. And so therefore, if there is an imminent disclosure or publication occurring, then step 4 may be left out until a little bit later. And step 5 then is the preparation of the patent specification, and to then file that at the patent office. Once it's filed at the patent office, you have a filing date, which is pretty critical in terms of securing your protection for your invention. The patent specification is a legal document, but it'll have a lot of information about your invention in it. There'll be drawings if it's for an invention that can be represented in drawings. It'll have a lot of information and discussion around variations and alternatives of the preferred form of the product. So the inventor is the technical expert, and the patent attorney is the legal expert, hopefully with the right technical knowledge about the area of technology that you're inventing in. So the inventor has developed a product or a process, and the patent attorney needs to know a lot about this product or process to then conceptualize it and then write the patent specification with the help of the inventor. Okay. And it can be an iterative process to help identify the desired scope of protection. So let's go through an example again about what I mean about the iterative process. So let's say the inventor has developed the bicycle. You'll see this appear throughout the presentation, this example. And we do some searching, and the closest prior publication is the unicycle. So there is an invention there. There's certainly something different about the bicycle compared to the unicycle to be able to protect the bicycle conceptually. But during the process of writing the patent specification, the inventor might say, well, actually, this is my preferred form of the invention, but I also came up with, so that this is the scope of the protection here, but I also came up with a tricycle, and that has similar advantages to a bicycle. It's a lot more stable than the unicycle. It's a little bit more expensive because it needs 3 wheels. So it's not my preferred form of the invention, but it's certainly something that I would not want someone else to copy. Okay. So potentially the scope of the concept then gets broader. It's no longer protecting the bicycle, a tricycle as well. Okay. And then during discussions with the patent attorney might say, well, why do you need a seat? Have you thought about a variation to a bicycle or a tricycle with a seat? And the inventor might say, well, yeah, I actually tried the scooter, and it's also got these advantages about being safer and more stable. It's not as comfortable because you can't sit on it, but it's certainly an invention that I want covered in my patent. And so you can see that iteratively, the scope of protection for the patent specification that you're writing with the inventor is creeping larger and larger and closer to the prior publication. But still, you know, if the only prior publication was a unicycle, a patent specification should be able to be approved by the Patent Office for a vehicle that comprises at least 2 wheels, covering both the bicycle, the tricycle, and the scooter. Okay, so when you're working with a patent attorney, questions that they should be asking include, you know, how did you come up with the idea? Are certain features essential or optional? You know, in the example before, you know, the seat turns out to be an optional feature. You could certainly drive a bicycle without a seat, so it's not as comfortable, but you want the patent to cover design around options, including bicycles without seats. The patent attorney should be asking what advantages each of the features has, what interaction exists between features, and explain past failures. Because sometimes past failures are about products that are 80% as good as the final product design, but still worthwhile protecting to stop someone else from coming in with a competing product that's 80% as good as your invention, because you may be able to force competitors to stick with competing products that are only 10% as good. A lot of questions get asked during the process of writing a patent specification, as you can see. Another thing that the patent attorney should be asking you is, you know, how will this new idea be commercialized? Questions like, where will you commercialize this invention, or where will someone else commercialize this invention for you? You know, potentially you're filing patents to then license or sell those patent rights to someone else. Patents are territorial, so if you want a US patent, patent application needs to be filed in the United States. If you want them in Europe, you need to file in Europe. There is no such thing as a global patent. So that's where the question about where and by who should come in. An IP strategy this discussion should be had, because sometimes for some inventions, it may be best to rely on trade secret protection to provide protection for the invention. So there needs to be discussion around what the commercialization strategy is and what forms of IP right are going to be the most useful or applicable for that strategy. Okay. There needs to be discussion around IP ownership. So usually the first owner of an invention is the inventor. And then from there, depending on the laws of different countries, the ownership of the invention may move to someone else. For example, if the inventor was employed by a company to invent, and they did so during company time and using company resources, then the rights to the invention are likely to sit with their employer. Often employment agreements exist to help deal with this situation in black and white. There should also be discussion around freedom to operate. So freedom to operate is about, it's about whether your product, your bicycle, can actually be launched into the market, because potentially someone else may still have a patent for the wheel. Okay, so maybe 15 years ago, the patent for the wheel was filed, and yes, you've come up with an improvement that's patentable because it's different enough to the unicycle and to the wheel, but the patent for the wheel covers anything that is round, and you selling a bicycle includes selling 2 things that are round, and therefore could be infringing an earlier patent. And this is often a misconception, and that is that you might be eligible for patent protection because you've invented something new, but you may not be free from infringement risks because someone else may still have a patent for the very broad concept. Okay, so just because you have a patent doesn't mean that, or you're eligible for patent protection, doesn't mean that you're free from infringing the patent rights of others. Okay, more questions that the patent attorney should be asking. And these are things that you can yourself answer before seeing a patent attorney to help smooth the process, to help speed up the process of engaging a patent attorney and to get the patent specification written. And having the answers to many of these questions prepared will also help reduce the cost of preparing and filing a patent specification. So there will be questions asked about publications. Are you aware of publications of similar inventions by your competitors or by anyone else? So we want to know, as a patent attorney, what the closest prior publication is to your invention. Is it the unicycle, or is it the wheel? Or perhaps the tricycle is the closest prior publication to the bicycle. We also will ask questions about who else have you told about this idea. So sometimes inventors need to help, need assistance to help develop a product. They need to get some partners on board, or an external consultant for some proof of concept testing. So questions will be asked around, well, who did you disclose it to? Were non-disclosure agreements used by you before you disclosed it to someone else? And sometimes, and I've had this possibly once a year, a new client will come to me and say, hey, I want to file a patent for this invention. And I'll ask this question, and I'll say, well, actually, I've been selling this product on Amazon, or it's been displayed at a trade fair 3 years ago. And that often means that we can no longer protect the invention that was disclosed at the trade fair or sold on Amazon. In some countries, there is what's called a grace period, and that allows for an inventor to disclose their invention to the public up to 12 months before a patent application is filed. It's a risky approach. The golden rule for patents is file a patent application before there is publication, but in some countries this grace period of 12 months exists. And patent attorney should also be asking, well, when does the patent application need to be filed? Now, are we in a rush to file this? Or do we have a couple of months or maybe a few weeks to prepare and the patent specification and work with you to develop it, to conceptualize the invention as broadly as possible? I've had situations where there was a rush to file a patent specification because the client had committed to a trade fair and the product was going to be displayed at the trade fair. And so we had to have a filing date before the trade fair opened. About this time last year, there was a real rush on patent filings for COVID-related inventions. And when there are regulatory changes or changes in the business environment where people need to innovate with solutions to new problems that have been presented, there can be a sudden increase in innovation and also a sudden increase or spike in patent filings. And the person that files a patent application at the patent office first for an invention has the right to that invention. So this time last year, with COVID just having evolved to the stage it did, we saw a large number of patent applications being filed for COVID-related innovations. Okay, but if you've got time, if there is time to file a patent application, then I also always suggest that some prior art searching is done. So prior art searching, you can do this yourself. There are free databases available. The Google patent database is pretty extensive and quite user-friendly now. You can search for prior art yourself. Before you go and see a patent attorney, you can turn up with your invention and with the closest prior art, and that can really help speed up the process and reduce costs of the preparation and filing of a patent specification. Okay. Sometimes it may turn out that what you thought was going to be very broad conceptual patent protection is no longer available because someone else has developed something very similar. And then you may not be entitled to any patent protection, or the patent protection may then be to a very small and specific part of your product. And sometimes the scope of the patent may be so narrow that it's not worth the cost of pursuing patent protection. But sometimes even patents for very small or incremental changes to old technology can be worthwhile securing. That's where the business model discussion, the business strategy discussion kicks in. It's balancing the cost of securing protection with the opportunity that exists for the invention. Okay, so we've seen this picture before. The unicycle is the closest prior publication, and the patent specification has been filed to cover all these variations. But what sometimes happens is that a prior publication comes along later on that knocks out a large proportion of the patent protection that you were hoping to get. So here is the rollerblades product. It has at least 2 wheels connected by a frame to transport a person over the ground, which is possibly the scope of protection that we wrote for our 2-wheeled vehicle covering the bicycle, the tricycle, and the scooter. Okay, so the only eligible protection that the inventor may then be entitled to is a small sliver. Okay, so searching prior art can be really, really helpful to anticipate that these publications may come along, that there are no surprises or very few surprises. Okay. The discussion should also be around, well, can your invention have other applications? And can the prior art searching may also reveal that you can make some improvements. So patent specifications, when they are filed, make a significant disclosure of the technology for which the patent is being pursued. And so patent specifications can be really useful for research and development. It may be that someone has already invented the wheel, and therefore you can use that as the starting point for your own development. And you may then end up developing the tire for the wheel, an improvement over the wheel. Okay. And it may also turn out that you find in your searching that someone has already invented a better solution to the problem that your invention is trying to solve. And you should also always question the commercial value of your invention and the merits of filing a patent application if you find there is prior art, prior publications, or prior use of earlier products that provide a better solution to achieving the same results. So prior art searching, you can do this yourself. We also do prior art searching with our clients, but there are some free databases available, Google, eSpaceNet, and a few others. What you need to do when you're doing prior art searching is to create a list of value-driving features in your product and search to see if anyone else has published a product with the same combination of those features. And if you find that someone else already has done the same thing, then you may not be eligible for patent protection, or you may only be eligible for protection that's relating to a small part or a small improvement rather than the broad concept. Another thing to note is that patents cannot protect ideas or advantages. Okay, so I can't get, for example, a patent for a faster way for traveling from point A to B. Okay, I can't file a patent for that. I need to describe a product or a process that achieves that faster way of getting from point A to B. Okay, so a patent specification must be defined, or a patent must be defined by the features or combinations of features that provide the advantage. And I'll give some examples of that in a minute. Searching, so prior art searching, when you get onto, for example, the Google patent database, you can type in keywords that describe your invention with operators like and or. Patents, when they are filed, they're also assigned a patent class. So that allows for you to search for patent classes for wheeled vehicles, for example, for wind turbines, for many different products. Some of the classes are very specific, so you can drill down to a lot of detail. You can also search on these databases for competitor names. So you can do a combination of these 3 different search strategies to find if there are prior publications that are similar to your invention. Okay, so let's get into a bit more detail around the process that we as patent attorneys go through with our inventors to scope out what may be patentable in a product. Okay, so here is the invention. And I mentioned before that you should create a list of all of the salient features of your product. Okay, and here is a list of all the salient features of the bicycle. It comprises of a frame, comprises of a first wheel, a second wheel, and it also says that the first wheel is in front of the second wheel is in front of the first wheel. So that's a relationship feature between two components. The bicycle's got handlebars that allow for the front wheel to be steered. It comprises of a seat, and there may also be a bell on the handlebars. Okay? And all of these things here may be really important to the sale of the product, or they may be important to the manufacturing of the product. Okay, these are features that you may be annoyed about if they appeared in a competitor's product, or if a competitor was using some of these things in their competing product. Okay, and on the left side, sorry, the right side here is where you'd list some of the purposes of those features. That's really helpful to communicate to a patent attorney why certain features are important. And that means also that you can potentially prioritize those features in order of importance. You can see that the bell is at the very bottom of my list. You know, a bell is nice to have on a bicycle, but it's bells and whistles. It's not mission critical to the product. Okay? It's just a nice add-on feature. Okay, so that's kind of the list that you create for your invention, and this is what you may go and see a patent attorney with, or this is something that you may develop with the patent attorney during the process. And then we pop into the prior art. So we've got the unicycle that we've seen before, and also the hoverboard. I've chucked the hoverboard in as an example. And then you compare each of these features against whether they are in the prior art. Okay? And you can create a list of yeses and nos. So the unicycle definitely has a frame, and it's got a first wheel. It's also got a seat, but it's missing a lot of the other features that the bicycle has. The hoverboard has got two wheels. So you can see that the hoverboard's got some features ticked as a yes, but also a lot of no's. This helps understand how far away the prior art is from your invention. This is a nice way to lay that out. Okay. The next step then is to understand, well, what is it that we're going to patent? And we saw before that we created that diagram showing the tricycle and the scooter. A patent, when we file a patent, needs to claim the invention, and often a claim is defined by the features of the invention. Okay, and in this instance, the feature that is probably of the most significant commercial value is the fact that there is a second wheel. That's not enough to get a patent, okay, because the hoverboard has a patent. Shows a second wheel as well. But here we have said that the second wheel is in front of the first wheel. And so this is where some novelty, some differences start to arise in the prioritized list of features of our invention compared to the prior publication. So potentially we can get a patent for a vehicle, so the bicycle, that consists of a frame and a first wheel and a second wheel, where the second wheel is positioned in front of the first wheel. And that distinguishes our claimed invention from the hoverboard. So the hoverboard sits outside of the scope of protection that we're targeting. We could also have chosen alternative to feature D, so the combination of A, B, C, and D. We could have chosen instead the combination of features A, B, C, and G and I. Okay, so I is about the bell. So we could have potentially filed a patent for a bell on a bicycle. We would have had to include in the scope of protection that there were handlebars, because the handlebars support the bell. So the protection would have been the combination of features A, B, C, D, G, and I. And when we write a patent claim that defines the scope of protection, the more features that are in the claim, the narrower the protection is, because infringement of a claim is determined whether a competitor has at least all of the features in our claim. So if our claim is for the combination of A, B, C, and D, a competitor would need to have at least those features in their competing product to infringe the claim. If we limited the protection to the bell on the bicycle, then if a competitor came along and made a bicycle without a bell, they would not infringe the patent. So this is where the balancing exercise comes in between understanding the prior art and understanding the concept that resides in the product, so the invention that resides in the product, and knowing what the value driving features in the product is or are. So let's have a quick look at infringement. Okay, so here we've defined our invention to be the combination of features A plus B plus C plus D. And I mentioned before that infringement will occur if a competing product has at least those features that we have claimed in their product. So what do we think? Do we think that the tricycle has at least all of those features? Do we think that the scooter has all of those features? What about the roller-wheeled shoe? Okay. Well, I believe that the tricycle and the scooter are both infringers of my patent for the invention defined by the combinations of A, B, C, and D. Okay. And that's because the scooter has at least a front wheel and it's got a rear wheel. Just because it has a second rear wheel doesn't escape it from infringing my patent claim, because I've defined my invention to consist of a frame, which it has, and a first wheel and a second wheel. And the second wheel is in front of the first wheel. Okay, the second wheel is there, the first wheel is there. That means that there is infringement of that claim. Okay. The scooter, that's also an infringement because there is a first wheel and a second wheel and there's a frame. Remember, we didn't limit the scope of our claim to there being a bell, nor did we limit the scope of our claim to there being a seat. The scooter does not have a seat, but it does have at least all of the features that I've defined my invention with in my patent. But this copy product, the wheeled shoe, doesn't have at least all the features of my patent claim. So it's missing a second wheel. And as a result, there is no second wheel in front of the first wheel. So this product here would not infringe a patent that I filed and I've been granted for an invention that has this scope of protection. Okay. Right, so sometimes a new prior publication comes along. So you've done a lot of searching before filing a patent application, and you think that you know that the closest prior art is the unicycle and the hoverboard. But sometimes, because time is limited, you don't do enough searching to find all of the most relevant prior art. And during patent office examination, an examiner might find that there is a rollerblade product already out there that was published before you filed your patent application. Okay. So that means that suddenly you need to adjust the scope of your patent protection, because the combination of features A plus B plus C plus D is no longer novel. Okay. You can see that the rollerblade has all of those things, and therefore your protection is no longer valid. But if you've had a good patent specification written, your patent specification will also include a lot of information about other features of your product, okay, other salient features. And that's often why a patent specification is really long. It describes the very broad and sort of basic ingredients of your invention, but it then also drills down into some of the more detailed features. And if a patent specification has been written from the outset like this, you then have options for amending the scope of your patent during examination. Okay. So now we've got an option to add into the protection feature E, for example, into A, B, C plus D. It's going to narrow the scope of protection because now the protection is about a steerable vehicle, and it's not going to cover the hoverboard anymore. It's not going to cover the yeah, it's going to suddenly become a lot narrower in protection. Yep. So a patent specification, when it's well written, is going to not just describe the broad concept and its basic ingredients, but also some of the important, commercially important detailed features of your invention. So possible protection that we might still be able to pursue is the combination of features A, B, C, and D. So it's a steerable two-wheel vehicle. Certainly the rollerblade has no steering wheel at the front of it. The prior art in the form of the unicycle doesn't have a second wheel that's able to be steered, and neither does the hoverboard. Okay. An alternative form of protection is the combination of A, B, C, D, and F. Okay. So maybe you've developed some front shock absorbers for your bicycle. Okay. So maybe that's where the novelty resides, and that's where important and commercially useful patent protection needs to be pursued for. An alternative is the combination I mentioned before, which is the handlebars carrying a bell. So a bicycle, two wheels, a frame, handlebars, and a bell. But we already know that that's quite narrow protection. So let's look at that pictorially. We're nearly there at the end of the presentation. I see there's a few questions popping up already. So let's have a look at that example that I just described in the table. So here is the original scope of protection. The client has invented the bicycle, but we've conceptualized it broadly to cover a unicycle, sorry, not a unicycle, a tricycle and a scooter. So we file a patent for the combination of A, B, C, and D, covering all those three variations. Okay. And we're entitled to do that because this is where the prior art sits. It sits outside of the scope of the claims of the patent. But during examination, this rollerblade prior art comes out, and it kind of blindsides us. We didn't realize that this was out there, even though we've done some extensive searching. Publications can come out of the woodwork from anywhere, from university libraries, from trade fairs. So sometimes these type of publications just cannot be searched for economically. And so sometimes, you know, some prior art that comes out as a surprise surfaces, and we need to be able to deal with that. And a well-written patent specification allows us to do that. And we mentioned before the alternative scope of protection. Okay, so we may be able to claim a bicycle that is that comprises of a front steering wheel, and that moves us away from the rollerblade. You can see that now the scope of protection is the combination of A, B, C, D, and E, and therefore is a lot narrower than the original scope that we were aiming for. Okay, the other example is that there is a front shock absorber for the front wheel. Okay, again, the rollerblade does not have that, neither does the other prior art. So we can potentially obtain a patent for a bicycle with a front shock absorber. The other example is the handlebars with the bell on it. And you can see that this circle is very, very narrow. It's very easy to avoid infringing that patent by a competitor who sells bicycles without a bell. Okay, or perhaps they put the bell on the crossbar and not on the handlebar. So it's a very narrow patent. Okay. But a patent attorney, a good patent attorney will spot that there is potentially something quite clever that can be done. So I mentioned before here that that you develop shock absorbers for the bicycle, but potentially the shock absorbers can also be used on a unicycle. And so potentially you might be able to stretch the scope of protection for the shock absorber to be useful for unicycles. And so suddenly you're outside of the scope of this original patent. And yeah, and that's a decision that you need to make or understand at the very start of the process of preparing and filing a patent. You know, are there any other applications for features of our invention that we've developed that we may want to protect in a patent? Because in that case, you would have drafted the patent to cover both the bicycle as well as a shock absorber, independently of whether it's used on a bicycle or some other vehicle. Okay, so yeah, that's the end of the presentation. I think we've got about 5 or 10 minutes for questions. So if you go into the Q&A portal, you're welcome to ask me questions there. The questions don't appear to other attendees, but I will read them out and then answer those questions. If you don't feel like answering or asking questions in this forum, then you can address questions to the marketing@AJ Park email that I mentioned before. Okay, so what are options if you cannot afford to purchase a patent up front, but you need to protect your invention? Okay, so this is a really, really good question. And I encounter this a lot with my startup clients. So startups are pre-revenue clients. They aren't making money from their invention. And so therefore, it's a really tough situation, because investors or potential investors are saying, well, what protection have you got for your invention? I'm about to give you a lot of money, but you know, I want to make sure that your really cool, clever technology is protected, and you know, you need to get a patent. Sometimes if you're in that situation, you might say to the investor, well, we're looking to raise money exactly for that purpose. So once we get you on board as an investor, we will then file the patent application pronto. Okay. Sometimes you're not in a situation where there is an investor around, and then you need to make sure that you keep your invention in the cone of silence or confidential until you have a chance to file the patent. So you know, sometimes you're able to develop an invention further and to prove its concept beyond its original idea, to then raise money or find some money from the 3 F's, which are the friends, fools, and family, to help pay for patent protection. If you're unable to do that, then there are what we call the grace period countries. And so these countries allow for you to sell your invention or to publish your invention, to generate revenue, to then to then proceed with patent protection. Grace period countries include New Zealand, Australia, Canada, the United States, and a handful of other countries. So in these countries, the patent law says that you can go out there and sell your product, make some money from it, and then if you then later on decide to file a patent, we will not hold your own disclosure against you as prior art. So your own disclosure of your invention can then be ignored as prior art. This is a risky approach to securing patents, but you know, if you're really stuck with not having funds to be able to afford to file a patent, then that's kind of the next best thing, I would say. Yeah, for typical simple mechanical inventions, the cost of preparing and filing a patent specification should be in the order of $4,000 to $7,000. For more complicated mechanical inventions, it can be as high as $20,000. One patent I filed for an engine that had about 5 or 6 different concepts to protect, that cost the inventor around about $30,000. A lot of money, but once you have a patent or a patent application filed, you then have a very strong asset for your idea. You become way more investable for investors, and potentially you can sell your patent. A company called Power by Proxy here in Auckland and New Zealand, they developed some technology for wireless transfer of power, and this came out of Auckland University. And they were a startup, they were a spin-off from Auckland University, and they sold their patents and their technology to Apple a number of years ago for many millions of dollars. And they knew that patents were an important part of their business model to generate revenue for the business, or a sale in this case. Okay, let's have a look to see what other questions there are. So for the example used in the presentation, would it be possible to utilize a combination of dependent and independent claims? So patent scope protection consists of numbers 1 to 4, as opposed to just one of them? Okay, yeah, so that's a really good question. So why have I, in my examples, always included the scope of protection being the combination of A, B, C, and D? Okay, why couldn't I have just claimed D on its own? Well, D on its own is for a wheel. We already know that a wheel exists. I could have claimed C and D, saying that there's two wheels, one is in front and one of them is and behind the other. But a patent examiner is going to say, well, there are two wheels, but what's their relationship? You know, what's their function? Why are two wheels useful? And you'll say, well, they're useful because when they are connected to a frame, they can give a vehicle much more stability. And the examiner will say, well, you need to include the frame in the scope of protection. Okay, so sometimes in a patent claim, when you're reading a patent claim, you'll read features of the invention that are already old. Okay, but somewhere in that list of features of a patent claim, there is at least one feature that is new. Okay, and in our example, it's the features C and D that is the combination that provides the newness compared to the prior art. That's a good question. Okay, I think those are all the questions I'm seeing. Here's another one. Can a process patent be granted, and can it be protected by a non-fungible token registration? Well, that's a very advanced question, and I'm not sure. I'm not an expert in this. It's a new area, non-fungible tokens, so I have not done any research on that. So unfortunately, I can't answer that question. Someone here at AJ Park may be able to do that. We've got lots of people that are interested in these new and upcoming areas of technology, but it's not one for me, sorry. Okay, in terms of protecting algorithms and software, is it always better to protect it via copyright, trade secret protection, as opposed to filing a patent? Okay, so that's also a very good question. You know, there's a balance between, sorry, some inventions are able to be kept as a trade secret forever. Okay, in which case, if that is the case, you're much better off keeping your invention as a trade secret rather than filing a patent. So if your invention is not able to be reverse engineered from the product that hits the market, and you're pretty sure that no one can figure out what's going on or independently come up with the same invention, at least for long enough for you to get a commercial advantage from your invention, then I would say don't file a patent, or at least have a really good, robust discussion around that. A patent specification is going to give away a lot of information about your invention, and will give you, if your invention is novel, 20 years of protection, but that's it. So Coca-Cola, for example, they've kept their formula as a trade secret because they were pretty confident that no one could figure out what it takes to make a Coca-Cola flavored drink. And so far they've been right, you know, so they've kept that as a trade secret. You need to have good processes in place to keep things as a trade secret. So for Coca-Cola, I understand that only a handful of people know what it takes to make a Coca-Cola flavored drink. So having processes in place to ensure trade secrecy is also important. But yeah, for software, sometimes the patent process can take too long. From filing to getting a patent granted may take 2 or 3 years, and by then the software may be obsolete. So sometimes the patent system doesn't really marry up well with some forms of technology. But again, a good discussion and on a case-by-case basis needs to be held around that. Okay, well, I think time is up. As I mentioned before, if you've got more questions, feel free to direct these to our marketing@ajpark.com email. Yep, I hope this was really useful to you guys, and yep, thank you for participating and attending this webinar. Thank you.